Siddharth focuses on private equity and venture capital transactions and on cross-border and domestic mergers and acquisitions. He's been highly ranked by all the ranking institutions out there for his excellent technical knowledge, his attention to detail, and for his global business practices. Siddharth is a gold medalist from the National Law School of India University. He's also received his master's degree from the University of Warwick, where he was a British Council and Foreign Commonwealth Office Chevening scholar and a J.N. Tata scholar. Siddharth is the founder partner of the Bangalore-based law firm called Saksha Law. This is his fourth law practice, so he's clearly an entrepreneur in his own rights and is speaking to the perfect audience over here. Siddharth teaches regularly as well. He teaches at National Law School. He's been a visiting professor there, as well as with Jindal Global Law School. He's also lectured at IISc and at the Indian Institute of Management. So clearly, this is a man who really knows the stuff today. But most exciting, actually, is the fun things that Siddharth does. He's a history buff, and along with his wife, he has curated the Nandi Valley Walks, which if any of you want to know about the history of our city and of that wonderful area of our city, the Nandi Hills area, you should do one of Siddharth and his wife Priya's Nandi Valley Walks. Truly entertaining, informative, and absolutely beautiful. And equally important for me as co-founder at CAMP, Siddharth is a trained mediator. He works with us. He's a mediation specialist with CAMP. He has mediated as well. So Siddharth wears many hats, and it's going to be a wonderful session with him today. So over to you, Siddharth, as you introduce the team today, or the group today, on the topic of formalizing business structures and founders agreements. Thank you so much for being with us.
Thank you so much for that very warm introduction. Thanks so much, Tara. I hope I can live up to some of those things in the course of this session. Good evening, all. We have a fairly large group today, so that's good. And welcome. Thank you for taking time out on this Friday evening. I do actually have a set of just some basic slides. Let me just bring up my screen. Just bear with me for a minute, please.
And while Siddharth does that, I do urge all of you to turn on your videos as much as possible. It's always more fun when the speaker has faces to speak to. So whoever has the bandwidth and the ability to turn your videos on, do turn your video on.
Great, thanks so much, Tara. Can you see this the screen?
Yes, Siddharth.
Perfect, great. So it's a bit of a mixed bag today. We're going to be dealing with several points, but I think they all relate to the issue of structuring an enterprise in terms of its key foundational elements, or should I say the key aspects of the skeleton or the frame around which entrepreneurs can then build their business, grow, scale up, etc. And so these are some of the foundational issues or topics that lie at the heart of the enterprise, and to make it as successful as possible. Now, this is the session, of course, as Tara mentioned, that we're going through TiE and CAMP. Specifically, I'm going to be looking at these 4 issues. Just a couple of housekeeping points, in terms of getting started. We are now at about 10 past 4. Session goes on till 5:30. I'm actually happy to take questions in line, So if people wish to, ask questions or provide inputs. In fact, a lot of times I find that at sessions like this, the comments and the inputs from the the cohort is equally important. So I'm happy to address some of those questions while going through the slides. So let's keep it as interactive as possible. I'm happy to do that. Except that at towards say 5:10, 5:15, I'd like to clearly keep some specific time for the Q&A itself to happen, the formal Q&A, if you want to call it that. So, over the next 1 hour or so, I'd go through, I've got about 12 or 13 slides effectively to just run through, but they're all really basically talking points. So that's a housekeeping point I want address. And I just request either Surya or Tara, I'm not sure if I can see whose hands are up and, who wants to come in. So please let me know. I don't, for instance, it's not easy to run the presentation and then have a look at the chat box at the same time. Okay. Thanks so much.
Yeah,
okay.
I'm requesting everyone also just to use the chat box. I'll man the chat box and interrupt where there are good questions.
Perfect. And of course, please keep until such time you speak, please keep your, mics on mute, right? And then you can chime in. Thanks. So these are the 4 topics, issues, if you want to call it that, buckets of points that I'm going to deal with. How to formalize a business structure. What are the essentials of a founder's agreement? And how can one ensure intellectual property protection through legal agreements, through contracts, in other words? And given the fact that this is a mediation-related session, how can one use mediation for resolving contractual disputes, especially in the context of the foregoing 3? If there's a problem with the business structure, or there's some kind of a dispute brewing between founders, or in respect of certain intellectual property protection, how do you use mediation? And that's the section where I'll also ask Tara to come in and give us some interesting insights and some actual live cases, in particular with regard to resolving disputes between founders. So let's get straight to that. Now, I've divided this section on the business structure aspect of this presentation, right? And it was interestingly that it was framed as a formalizing a business structure. So the way I look at it is essentially at the start of an enterprise in the early days, what are the legal considerations one takes into account in the type of business entity or structure to incorporate or to set up. And then there are, of course, operational related issues, which I will come to. So I look at it both purely from a legal perspective, as well as from an operational perspective, in the sense of how do you structure employee related matters, right? And how do you address issues relating to incentivization and enforcement of contractual obligations? I think that's an equally important part of a business structure. So essentially what I'm doing is taking the case of a new enterprise. And if I were to put myself in the shoes of a founder in that new enterprise, from this particular viewpoint, I'd ask 2 questions. What's the entity structure? What do I do in terms of the legal niceties about it? What do I put in place? And then, of course, with the team, with the people, and with all of the rest that we need to operationalize, especially people, what are the key kind of issues at the threshold or aspects to be dealt with while setting up and formalizing or institutionalizing such a business structure? So there are 2 parts of this bucket on business structure. Now, of course, I will run through this. This is a pretty obvious thing. These are the kind of entities that are available, right? Now, of course, you can always invert this pyramid, right? The sole proprietorship being the bottom and then going all the way up to the top, right? In terms of the types of entities that are available in this country, right? I will, by the way, deal with the aspect of, what I call externalization. That is when you end up potentially with a overseas holding company and in India operating company. I'll deal with that at the fag end of this particular bucket. So suffice it to say that for this presentation, in the interest of time, right, I'm going to look at 2 potential options that are there, most preferred. I put a question mark because I must, immediately put a caveat on all of this. None of these principles, are legal advice in the sense of any specific circumstances. Ultimately, you tailor a structure or an entity or the types of organization to your specific facts and circumstances. And they may well be very different and myriad, right? So as a result, what may be applicable to one may not be applicable to the other, right? And so while, you do essentially kind of boil down to the most preferred route in this country as being that of a private limited company, there are certain other options. And in some cases, though it must be said in the minority, from an investment perspective in particular, people do look at this new, well, fairly new, it's been around for a little more than a decade now, the concept of a limited liability partnership, right? It wasn't there until 2008. So to the extent that it is only in the last decade and a half that we've got this new structure in place, there's a certain amount of discussion that can happen. As I say, in my experience, oftentimes this is not even a point for discussion, especially, as I said, in the context where you want to be investment ready. And so consequently, the most preferred, if you want to call it that, is a private limited company. As someone once famously said, right, that I can tell you that an open heart surgery is less effective than a angioplasty, in that you have greater chances of success and survival in the case of an angioplasty. But if you don't come through an angioplasty, that particular statistic is, as far as you're concerned, of no consequence because you're dead. So I don't believe, in putting that out there as a statistic, but just to give context to this. So I think this is let's quickly go through this in terms of, now, again, is it a question of advantage versus disadvantage? I always ask these questions.
I'm using my phone.
Hello, sorry. There are these essential kind of touch points or markers that we need to keep in mind, right? Now, as you can see on the left-hand side, and I'll deal with the private company structure first, the most essential positive element over there is obviously the fact that one can receive money more easily in a private company in the sense of the structuring of the capitalization table, primarily in the context of investors, right? Because you can create different classes of shares and you can vary those terms of those different classes accordingly, depending on the relative strengths of investors and when they came in, and obviously at what valuation and how much money they've contributed. And I think the core legal reason for that, just as a point of information, for the first 2 points on the left-hand side, is the fact that the strict distinction between equity shares and preference shares in this country is kind of much more fluid when it comes to private limited companies, right? Because you can exclude the strict differentiation that exists in law between an equity share and preference share. Someone famously once said, a well-known professor, that if you are told you should prefer a preference share, then you are sorely in need of some legal advice, right? So the question of the preference share is a question of the preferential right. And stricto sensu in the law, the only preferential right a preference share in a public company has is a return of capital, right? And a first right to dividend. But of course, as we know, that when it comes to private companies, those distinctions can be broken down by a huge plethora of other rights in respect of which a preference shareholder, i.e. in this context, an investor who's putting money in, can thereby provide. And so on the flip side, when it comes to founders or promoters, the question is, how do you deal with the inter se rights and obligations matrix between promoters holding equity shares on the one hand and potential investors coming on board who will have different classes of preference shares on the other. So that really is the core of that issue to be asked, right? And that is, of course, the greatest advantage of being in the private company. Now, over the last 10 years, the regulations in terms of compliances and regulatory scrutiny between public and private companies has started to converge ever since we had the new Companies Act, well, now 10 years old almost, in 2013, introduced over the 3-4 years thereafter. The original principles of corporate law made a very clear distinction in this country between public companies on the one hand and pure private companies, that is non-affiliated, non-public affiliated private companies. And the advantage in the latter was hugely there in the law. The essential feature of the New Companies Act is to converge those two regulations, because the regulators have realized, playing catch up, that Indian industry has started to use the device of a private company, even in the context of corporate groups that are led by public listed companies, majority of whose associates or affiliated companies are private companies, can then be used as a kind of a tool to get around the strictness of the regulations in the public company case. So what the law did was to say, let's converge the two. And so we now typically will, in normal circumstances, find that most of the regulations seem to apply across the board. Of course, there are specifics, which, as I said, for instance, the segregation between the types of shares, which does not apply to a private company. And there are, of course, other issues when it comes to things like independent directors, etc. I won't get into all of that over here, right? And then, of course, and the last point is that it is to that extent much easier to let me be very clear. It's relative, much easier, not completely hassle-free, to withdraw capital, right? So that is another quote into quote benefit with a question mark over there, right? And on the right-hand side, when you look at LLPs, some of those advantages, again, I query, because over the last 10 years, if we were having this discussion, for instance, in the year 2012, I would say that the LLP was going to be, a huge contender to upset private limited company in terms of the vehicle to be used, right? And so therefore, because we now have this convergence between regulations between public and private companies, some of these so-called advantages that LLP has, and because of other changes in the law, we've kind of had a merger that's occurring. I can see there's a person. Right, sorry, that's Surya. Thanks, Surya. So that's a broad brush overview in the context of time that I have. Now, if you look at the last point on that slide over there, which I call externalization. Now, this is increasingly in the last, well, I should say over the last 4 or 5 years, really, but especially so now, become an issue for many early stage companies and entrepreneurs to consider. And that is potentially having a corporate structure which does two things, which has a holding company, right, and a subsidiary, in other words, a pure parent subsidiary or holding company affiliate structure, but with a border going between those two. And many Indian entities have found it efficient commercially to have their holding companies in an overseas jurisdiction, whether that be Singapore, whether that be the US, or potentially one of the tax havens, with the India company being the wholly owned subsidiary of that overseas entity in India. And so the operating company is actually 100% subsidiary of an overseas holdco. Now, this structure, by the way, we have, potentially kind of borrowed. The Chinese, when I was working in Hong Kong almost 15 years ago, the most preferred investment structure going into China, even at early stage, was what is called a WOFE. That's a wholly foreign-owned enterprise. And you would set up a company in Hong Kong, for instance, or even in the US or Singapore, less so. But you'd essentially have an overseas holdco, which would then hold the operating company in China 100% from overseas, and therefore seek to avoid some of the Chinese regulations by effectively taking that structure overseas, or as I say, externalize it. Now, both the Chinese authorities as well as the Indian authorities soon realized that this structure meant that they had to regulate it, right? And so I think the key issue, and I've laid out the 3 points that I think are important over there, but overlaying all of that, the need to have a holdco and IndiaCo structure like this must be driven not by legal considerations or tax considerations, but it must be driven purely by commercial or business considerations. And in fact, in the last few months, and currently also, I'm dealing with at least 3 companies who have either got into this or who are considering doing this. And I think the key point in the companies that have actually got a holdco, in one case in Delaware and in the other case in Singapore, is entirely driven by the fact that those companies, from a business or an operational point of view, want to be seen to be close to either their investors in those overseas jurisdictions, or more importantly, their customers, because that's a company or enterprises that have a large overseas focus. So driven by that, in this particular case that I'll take the example of, we had a very early stage company set up a Delaware co by others, by relatives who could then gift that enterprise to the India promoter, which then went ahead and raised funds. And in the process of doing so, made the India operating company, which had also been recently established, as a subsidiary of that overseas holdco. Now, the advantage of doing that, and those are the three issues that I've highlighted over there, is there the possibility that an Indian authority could say that, hey, this is effectively what is called round tripping, money going out of India and coming back in, because US promoters are India based. You've gone and set up an enterprise in the US, raise some money over there, and then you bring it in. Or you're taking money out over here, setting up the enterprise and bringing it in. Those are very valid questions to be looked at, and the web of regulations in that respect must be considered. The other is, of course, a tax consideration, and I'm not a tax lawyer per se, but I can tell you that the issue of the place of effective management, right, or as tax lawyers like to call POEM, it's not as poetic as that, unfortunately, is whether the Indian authority can claim a jurisdiction or the ability in law to tax those enterprises. And then, of course, the question remains that ultimately, if the funds, wherever raised, especially if they're raised overseas in this context, will ultimately have to be brought into this country in some proper manner in order to actually make the business work. So that's a set of issues that I think are important for people to consider. Now, as is always, this thing doesn't work after some time. There we are. Sorry. All right. So after we look at some of these legal considerations on the business structure, as I said, I broke it up into operation and what I'd call the organizational chart, which is important for early stage enterprises setting up, to consider right at the very start from an organizational structure point of view. And I've, of course, focused on key employees, but it could be others. If you look at the pyramid again on the left, I think that kind of brings the legal aspects out. You have executive directors and non-executive directors and key managerial personnel, people like the CEO, the CFO, of course. And I will deal with the issue of who is a founder and who is a promoter in a short while. But I think the key, from a legal point of view at least, which is what I'm competent to talk about, is that the issue is the concept of officers who are in default. Now, these are people on whom liability in law can be affixed. It's a hook, right? If something goes wrong with the company, if the company is liable, remember it's a juristic person. If the company is liable, if it's a fine, yeah, you can impose it on the company. Many of the laws provide for imprisonments and fines on officers. So who is the person who's in default of obligations? Remember, it's not officer who's in control, but it's an officer who is in default. And our law on the point is very wide ranging. Just a couple of weeks ago, I was addressing a cohort at the IIM Bangalore on independent directors' roles and responsibilities. And one of the issues that I brought up was this, is that note that an officer who is in default could also include an independent director. Don't be sanguine in the fact that you are an independent director and can therefore say that I'm not liable at all for what goes on in the company. Far be from the truth, actually, because that is really an issue to be considered. Now, if you keep that left-hand pyramid in mind for a minute, right, I think there are two essential markers, if I can call it that kind of, people ought to keep in mind, right? One is, of course, the important one of which seems to be the issue throughout corporate India today is how do you retain people? How do you attract and retain people? And then potentially, how do you get rid of non-performers, right? And I've been seeing a number of those cases. In one situation where I had to act for the employee, one of the key employees and key managerial personnel in question, who was being accused of not having, done his job properly. And really, that was an issue that came up, right? And of course, we have things like, questions of the stock option pool, several rules on that point. Suffice it to say, the most critical aspect there is dilution of your stake. and potentially of control, both in the context, especially, sorry, I should say, in the context of any investment coming in, because ultimately that pool that you keep aside, or the reservation of shares that you keep aside for a stock option pool, will essentially come out of the founder's pockets. So how do you deal with those cap table structuring issues, right? The formalization of one's cap table, by the way, who gets how many shares and at what value, is increasingly becoming a very important aspect to be considered. And there are many entities now, like Carta, for example, in the US, and there are, by the way, Indian entities as well, that are starting to offer early stage companies these kinds of services for pretty nominal consideration, money and fees, because it means that you can structure some of these considerations upfront and by projecting into the future, right? Exclusivity, of course, is that you must ensure that people devote their full time and attention to this, and we of course have the concept of a whole-time director, which is there on the left. And then quickly running through, I think in the interest of time again on this, one of the key aspects of the org chart is how do you, again, purely from a legal prism, is how do you ensure that you are able to hold people to obligations that they agreed to during their employment for periods that may extend beyond the employment. I think when it comes to things like non-solicitation and confidentiality, those are clearly aspects that are a matter of valid enforcement, even beyond the term of one's employment or association with a company. Non-competition, on the other hand, in the employment consideration, is a no-go beyond termination of employment, right? And if you've heard it before, that there are reasonable restrictions, or that there is a concept of reasonableness in a post-employment non-competition provision, that is incorrect in law, in my opinion, right? The only aspect of reasonableness that comes into the picture is when you are seeking to enforce other negative covenants, such as, for example, a non-solicitation or a confidentiality protection, or potentially, and drawing from the point I raised above, where the company has expended costs on one's training, and therefore, through that route, act as an item of deterrence, as a feature of deterrence, in order to ensure that people stick to their post-termination obligations. Now, as a matter of enforcement, will the court grant an injunction or a stay when it comes to a perceived violation of these negative covenants post-termination? I think the only way to restrict someone, quote unquote, quote, joining a competition is to go through the more circuitous route of saying, and therefore building up the contract in such a way that both the aspect of confidentiality and non-solicitation, or other reasonable costs incurred on that person during his or her employment, act as a hook on which to say, unless those monies are paid, and therefore it becomes a charge on that person is effectively, although not directly, prevented from indulging in dangerous activities such as, for example, joining competition. Now, I appreciate the point that it is an important business aspect, but the law on the point, as far as employees go, are quite clear. And the only way really to structure this is to think a little out of the box, so to speak, and see how else one can act. One can provide effective deterrences to such negative covenants actually having a bite in the matter. All right. I will just move straight in. Any thoughts, questions on this section?
No, Siddharth.
Right. All right. So we now come to the second one, which is founders' agreements. Now, in law, the term promoter finds definition in our law. And a promoter, if I can just take a minute to go, is a person named in a prospectus, right? Or is identified by the company in its annual return as a promoter. Prospectus, of course, is when it comes to issuance of shares to the public. And a promoter is one who has control over the affairs of the company directly or indirectly. whether as a shareholder, director, or otherwise. And anyone who, in accordance with whose advice, directions, or instructions, the board is accustomed to act. Now, that's the legal definition of the use of the word promoter. Now, I think it's a bit of a nomenclature over here. Essentially, you're dealing with a set of entrepreneurs. I'm obviously in the context of a team of entrepreneurs over here, because that's why we think of inter se agreements or an understanding between them. Now, whether you call them a founder or a promoter to some extent is a bit irrelevant, because you're clearly identifying people who have started and who control and drive the company, right? Ultimately. And so the issue really is in terms of operational roles and responsibilities, what are people going to do? But just to complete that point, the term promoter finds definition, right? Obviously, someone who promotes the company, but that could be anyone, right? It need not necessarily be the founder. But I won't get into those technical aspects. I think ultimately, when it comes to a question of rights and obligations, it's a question of what rights and obligations have been formally undertaken. Now, before I dive into some of the aspects of it, and I think I have it actually on the next slide, is actually to ask the question, the threshold question is, do we need this, right? Now, there again, it's not one size fits all. There's no cookie cutter answer to this. It depends entirely on the business, the level at which it already is, the experience and the composition and the legacy, if you want to call it that, of the promoters. But essentially, what are we talking about? We're talking about these 5 points that you see on the screen, right? We are essentially talking of a division of roles and responsibilities, duties and decision making, right? Now, that is true of any enterprise, whether it be an early stage enterprise or a much later enterprise or a family run concern. Ultimately, what breaks down an enterprise is disputes in relation to their respective roles, responsibilities, duties, and most importantly, decision making. So if you ask me, have I seen many founders agreements? I'd say 50-50, because in many cases, founders are quite clear that in any event, this issue of their respective roles and responsibilities will kind of get fixed when you get external funding into place, because an investor who's put money in is keen to ensure that his or her money is then properly managed. And so the first port of call is to ensure that the respective teams function properly together. And that is a purely operational aspect. It's got nothing to do with the law, right? And so I have actually heard it from many founders saying, listen, we've got it very clear what we are doing, and we have a clear understanding with potentially an investor who's coming on board, what it is we're going to do, and our respective roles and responsibilities. So therefore, we don't need it. I think that's an important threshold question to ask, because in one case, and I'm not at liberty, unfortunately, to mention names, we ended up with a situation where the founders felt that the 4 of them were perfectly working as a team. But as soon as external money came in and the company was moving at a different level, some of the founders realized, as is the case with most human interactions, that the other founders were not pulling their weight. And so consequently, essentially a split occurred. And the greatest, problem arising from that split, from any of these dissonances between founders, is that the functioning founder, the guy who's actually driving the business, thinks that his colleague, him or her, who is named as a founder and has joined as a founder, isn't pulling his or her weight. And so therefore, the upside in any transaction and in any valuation increase is afforded to people who are not deserving of it. And that can be a huge dissuading factor. So there's both pros and the cons of doing such a thing. And I think it's important to understand, as I've written in the third point, is it a base that you can put in place for future funding rounds? And is it more importantly a base to put in place to obviate or mitigate a conflict in the future amongst or between one or more of those founders, right? So those are three threshold issues that I think are critical. Now, immediately built on top of that, in terms of a brick, if I can call it that, is to examine, and I'll do that in the next slide, as to what this inter se arrangement is primarily when it comes to the shareholding of the company, right? As I say, transfers and vestings, and I'll come to that in a minute. Now, one aspect is that obviously a founder, in the capacity as having certain obligations to his or her co-founders, as well as to any incoming investor, is to have skin in the game in the concept of them being actual owners of the company, right? So you could, and I have seen this as well, that you may well have key managerial personnel who are not founders in the strict sense of being shareholding founders and thereby controlling owners, but without such shareholding, but yet having certain obligations cast upon them, in most cases in a non-founder situation, right? Because of the potential absence of skin in the game at the start. Of course, as we've seen in corporate India, especially over the last few years, someone who began as a key managerial personnel as an employee may have evolved into being a founder at a later stage, or a promoter at a later stage. Actually, the proper term would then be a promoter. He hasn't founded the enterprise, but he's become a key promoter of the enterprise. And therefore, that translates into a skin in the game in the context of getting an ownership stake in the company, which immediately means that there are rights and obligations cast and certain rights vested in the hands of that founder. So again, keep in mind that this issue of, it's actually a classic corporate theory that goes back over 100 years, owner manager, right? What's the distinction between the owner and the manager? Is it fused? Is the owner the manager as well? Or is there a distinction between the owner, the capitalist on the one hand, and the labor, so to speak, on the other? And I'm using leftist terminology, but deliberately to prove the point, right? The labor or the employees on the other hand, who are not stakeholders, well, I should say shareholders, but they've become stakeholders in the company over the period of time. So I think the last point to just mention over here before I go into some of the specific aspects is that this issue, and I made a point of it at the start, do you need it? And if you do, at what time? Those are important considerations, because it's a very dynamic situation. Because it may well not arise at all, because you'd have an investor or a shareholders agreements put in place that crystallize all of the duties of the founders in particular. But the question is, how do you deal with inter se issues amongst the founders, which could well be a situation that may require to be covered, right? Now, so these are some of the specific aspects that I just want to quickly run through. I'm mindful of the time; it's about 4:45. These are the 6 items that I want to talk about, some of which we're going to cover in subsequent slides as well, right? One of the things that should go into such founders agreements is who's going to decide potential dissonance between the founders, right? That's an important commercial point, by the way, right? So if you have 3 founders, I mean, who's the first amongst equals, so to speak? Primus inter pares, as they say. You know, there's a famous Jeffrey Archer novel by the same name, by the way, from the mid-1980s. And I'm only referring to it because it talks about the jostling of power between 4 very dynamic individuals, all men, who are seeking to become Prime Minister of Great Britain, right? And it's a fascinating book about the way in which power can change, ebb and flow of power. We're seeing that very clearly in the UK currently, how power can quickly come and quickly go. And therefore, how do you decide respective, roles? Sorry, I beg your pardon. How do you decide who decides what the dispute, how the dispute can be resolved? I think that's a critical thing. By the way, I myself have faced that, because in partnerships as well, I mean, including in service industry partnerships like mine, professional services, there's always that question amongst partners, right? What's the dynamic? That's really the word for it. What's the dynamic amongst founders? And I don't think any law other than the contract law can help one over there, right? I've mentioned, by the way, briefly the role of an independent director. I say that because I say that because I came across such a situation that where you potentially may have some external senior person, right? And it's typically in the Indian context, someone who's, senior both in terms of experience and more typically in terms of age, who can arbitrate or mediate that dispute. Some of those aspects of mediation, of course, we will talk about a bit later, but I'm only asking the question again, whether there is potential for a third party divorced from that situation. Although if you ask me, an independent director is not technically a third party to that circumstance because he or she is involved in the company. But that's again another thing I throw out there for your consideration. I can see that Deepak Srinath. Oh, good evening, Deepak. How are you? How would first among equals work in a two-founder entity?
I said that. This is Deepak here. Yes.
How would first among equals work in a two-founder entity? Well, the short answer is it would never work.
Correct. That was my confusion.
Yeah, but but let me just overlay a point on that since you raised the point. It's a good point, by the way. It could also be, it's really a question of if I go back again to Jeffrey Archer's book, right, and what you're seeing in England at the moment, it's a question of the what should I say, the power and the perception equation, right? Who has the ability to decide agendas and influence outcomes? I think one of the most critical aspects of inter se adjustments amongst founders is not just, who's brought in how much and what's their capacity and what's their role, but it's a question of agency. How much can you influence agenda setting and outcome generation? Now, that is entirely a matter of factual circumstances, because even if you began with having all power, you could very quickly realize through the acts or the inactions of others or your own inaction that you've lost the ability to control those decisions or influence those outcomes. That's when you've lost that. The equation between the founders have then broken down, right? Then there's an issue then. So in a two-founder situation, you will essentially have to then mediate, to my mind. I mean, of course, there are obviously going to be circumstances which prove otherwise, but I think that's one thing that I can say immediately to that, right? So
thanks for that.
Thanks. And please feel free, Deepak, to come back in if there's anything. Now, the other thing that is important between founders is how do you treat transfers of shares between founders, right? So, and there are various circumstances for this. It's happened in the last 18 months. I've had two situations again. One founder is suddenly in need of cash because there's a medical emergency, right? And I think the last 2 years only proves the point that these kind of unfortunate events can happen overnight, right? So you need to get cash. And one of the assets that you have is your share in an enterprise, right? So you want to transfer it. Of course, if you've got investors around, there's always another layer of rights and obligations, but I'm talking of in a pure, founder situation. Obviously, you'd go to your colleague and co-founder. Now, question arises, if that's going to happen for bad things, it could also be something good. For instance, you need money to fund a child's education overseas, or whatever, right? And so therefore, liquidity, right, in any situation, whether you are a investment company or you've been invested in already, is how do you deal with what we call permitted transfers? Now, permitted transfers, of course, is a term that has emerged, right? It's not as if there's a legal connotation to it. It's essentially certain types of transfers up to a certain limit that you will allow amongst founders or potentially with an external party, say, for example, an investor. So in this one particular case, a Chennai-based company, the other founder said, listen, I really want to help my co-founder, but he's in a bad shape. He needs the cash for a medical emergency. I don't have the cash right away. So the investor stepped up and said, listen, I'm willing to give the guy, the money. It was about just under 1 crore. and he did it through a transfer. Now, and we were actually acting for that investor. And I mean, realistically, I raised the point. I said, listen, this is an immediate situation, right? In God, God willing, the medical emergency will pass. Then what happens? Are you going to treat the founder less favorably because he's happened to have lost some skin in the game? And the investor in this case said, no, we're going to find other ways. I mean, I can't obviously transfer the shares back to him at less than value because I have legal implications for that. I'm a fund, I can't do that. But we're going to find ways and means, and we're going to do that through the company, that we will ensure that he gets, quote unquote, recouped or, some kind of recompensation for what he had to do given the adverse situation, right? So it resolves itself, as you can see. How much of this can be captured in a situation where none of this is already visible? If we had the benefit of hindsight, we would have done all of this in a document, but we don't have the benefit of hindsight. We're only trying to look crystal gaze and consider the situations. And so my response, and I'll end with this on this point, is to say, think of all the possibilities. There could be good, the bad, and the ugly, right? And how do you deal with it? It's better to deal with those principles that you would apply to such kinds of permitted transfers in a situation where none exist, whether it be good, the bad, or the ugly, right? And that ugly one, of course, is the fourth one that I talk about over there, where you have to kick a founder out for non-performance. I've had that happen also in the last few weeks. We've spent 6 weeks, by the way, working together with the other co-founder and the investor to get rid of a co-founder because he simply wasn't carrying his weight, right? And it wasn't as if he had done something wrong. It was just that he was no longer fit for purpose. He was no longer the guy who would deliver on the objectives of the company because it was beyond him. And to that extent, there was a loss of confidence. Incidentally, the Indian labor law, which, by the way, has undergone a huge change in the last 1 week, and that's another matter to be dealt with, is, the absence of confidence or the loss of confidence in someone is a well enough ground, provided principles are adhered to, principles of natural justice. Again, it's a question of who decides what is going to happen when someone does something bad. Someone has to go because there's, unfortunately, he's got a medical condition to attend to. I've had that happen as well. In fact, I mean, let's go to the far thing. A year and a half ago, just 2 weeks after a large Series B fundraise, the CFO of the company dropped dead, right? Now, of course, it means a huge shock to the family, but, consider the enterprise that he or she has left behind, right? And what happens to all of that? Because from a business perspective, directors on the board and other co-founders have duties to their constituents. And so therefore, while you take care of the unfortunate, family, how do you deal with issues relating to, finding a replacement? And the company took a good year and a half before that it came out of those woods, so to speak, right? Again, in the interest of time, I'll quickly run through. Sorry, is there a question on the chat? I don't know. There is. There's a large question. Is that Satish Kumar, right? Can I come back to you, Satish? I'll ask you to state your question. Let me finish this slide and I'll circle back to you in a minute. Yeah.
Thank you, Siddharth. Thank you. I appreciate it.
Yeah. So the other point I want to talk about here, again, in the interest is this concept of vesting. Now, I'm sure many of you have heard about it, right? It is a US concept, which is essentially what? In the US, you have a proper legal framework for it. That is, a founder's share gets released to him, right? In other words, he gets the benefit of it over a period of time, right? So, and that's really a tax issue in the US, and I don't know too much about it, but all I can say is that a founder kind of creeps into his ownership because he sticks with his business. So if the founder stays true to his original plan, says, I'm going to do this business, grows it, and the business is growing and is still a going concern, then over that 3 or 4 year period, he will get up to 100% of the shares that are his. But before that, there's the possibility that those shares can be dealt with or taken away from him, depending on the circumstances of his separation from the company. Now, in India, because we don't have the concept of what is really in law a partially allotted share. In India, you can either issue and allot a share, or you cannot issue and allot. And once a share is issued and allotted, the rights and obligations or the benefits of those shares come to the hands of the shareholder. So what you need to do is to overlay the law with a principle of contract, which says that of the 100 shares that you own today, Mr. Founder, you will not get the benefit of dealing or transferring in it, or the economic benefit sometimes, right? There's really no economic benefit in the early stages of a company because you're not generating much profit, really, probably none at all, right? So the question is, can you deal in those shares? Well, we tell you that for the first year, you can only do so with 25% of the shares, right? And so you take the concept of the restricted share in the US and flip it by putting a vesting schedule, or essentially a contractual obligation not to transfer or do something with those shares, not to, as we in the law call it, not to deal in the shares until such time it becomes fully yours and free of any restrictions when it comes to the types of separation involved. Now, that's an important tool, by the way, to also use between founders to figure out their respective situations, because both founders must realistically look at and say, I mean, I don't know, if one of us gets hit by a bus tomorrow and dies, what happens to those shares? I need to know, because as the other founder, while I am fully, as I said, mindful of the need to, help the unfortunate family, I still have other issues and other interests and other obligations, duties, if you want to call it, in some cases, fiduciary duties to deal with on the other hand, right? So that's an important aspect to that as well. IP assignment, of course, is important, especially in tech-heavy companies, right? Now, suppose the founder who's unfortunately separating has been the one who has helped develop the platform that is the basis of the product or whatever it is that the company does. It shouldn't be that the moment he goes away that those rights go away, and we'll talk about it in the IP assignment section. And then, of course, there are these issues that I've already alluded to: confidentiality, exclusivity, non-competition, non-solicitation. Suffice it to say that when it comes to promoters, the ability to enforce a non-competition provision in the context of business, right? Because the exception in the law is if there is goodwill involved. So, for example, a partner in a law firm, and by the way, I'm saying this because there is a specific provision in our partnership law, not the limited liability partnership law, but the main Indian Partnership Act of 1932, which says that because a separating partner has an aspect of goodwill, and therefore there is a basis to say that because of that consideration, the remaining partners can expect to put a bar on that outgoing partner not to compete or not to deal with the clients that he or she was dealing with in the earlier firm, and that is enforceable. So the thought again is to ask, of course I'm talking of in the context of the partnership law, is that where does it extend when it comes to founders as shareholders, not as employees? I'm talking about the shareholders. Can there be an enforcement of the non-competition restriction on an outgoing founder when it comes to his share in the context of him being an owner rather than a manager, right? As you can see, and I'm going to sum up on this slide, is that these key aspects, all of these 6 key aspects, sadly, deal with either a disputative situation or an exit situation, because most founders agreements, and I'll end on this, most founders agreements spend all their time considering what happens when things go wrong, right? And the 2 obvious ones are, how do we solve for a dispute? And hey, how do we deal with one of the founders not being there because either he had to go or he was called to by his maker, or we felt it was time that we went our separate ways. So unfortunately, we only deal with the issue of the exit. I am going to move to the next slide. However, just give me 1 minute. All right. Satish, I think, this is a specific question. Can I take it just at the end, please? We're about 5. I'll deal with it in the Q&A, the start of the Q&A.
Sure, please.
Thanks.
Carry on, Siddharth. Thank you.
Thanks. All right, so let's move on and just want to get this. Right. IP protection through legal agreements. Now, I want to talk about three particular buckets again, sub issues, if I can call it that, right? And let me start with the points at the bottom. There are essentially 2 types of intellectual property protections. These are words that I just came up with. I think these are useful tags, so to speak. The first bucket is systemic. Trademark law, patent law, copyright law, the designs law, for instance. These are all structured legal provisions. There are specific statutes, there are specific rules, and there are specific ways in which entities and individuals in those entities can structure and thereby protect their intellectual property within the enterprise, right? Is to rely on the law, right? And let it be said that these laws are fairly robust. Many of the laws had to undergo a number of changes, right? For example, our trademarks law, right? Indeed, even our patent law. And so I think it would be wrong to say that the Indian legal provision does not have bite. It does. The question is, how do you use those principles to your advantage, right? That's the systemic protection. What we are talking of in this session is what are the contractual rights that one can overlay over and above and beyond that, right? And I think the best example for that is actually trade secrets. Now, there, essentially what you end up doing is that through the building base, the foundation, the building block is always the systemic rules that already exist on intellectual property protection. On top of that, you build your house of IP protection, and that house of IP protection is nothing but an interlay between different contracts, right? And one of those examples of that is a trade secret, because these are things which are much more ephemeral. They are softer. They lie in the minds of people. How do you ensure that certain ways of doing things, not necessarily something that you can put your finger on and say this code or that drawing, but the ways of doing things, how do you protect that when dealing with third parties, for example, customers or vendors, right? And there you need to be clear that you can do this through a combination of non-disclosure and confidentiality protection, as well as through acknowledgement of proprietary rights, property rights in the way you do things, right? And obviously there's a lot about this. The entire patent law, for example, is dependent on the way of doing things and what you do. I don't want to get into that because that's a hugely, that can take a full course in a law school, right? But suffice it to say that the way of doing things is important to crystallize and protect over and above what the base of the law is. Now, that's only one part of it. Now, the 2 other aspects that I talk about above is that when it comes, especially in the software industry or in the wider technology space, is obviously the creation or the authorship of intellectual property in its soft form, right? In terms of code, in terms of, as I said, ways of doing things, in terms of platforms. I think the key point, many of you will probably know this, is that there's a distinction between the author or the creator and the owner. The author or the creator is the initial owner, but it's not necessarily there for all time. Because if you've done your work as an author or a creator of a particular intellectual property, no one can deny your moral right to it, right? You pick any book that you want, and you will see on the first page, on the inner page, the moral rights of the author is asserted. That's obviously going to be the case. But that author has provided Penguin the rights to publish it. And so therefore, there is that concept of an assignment of the right. But I am asking in the context more, I should mention, where you have an employer-employee relationship. And the principle, and again, I'm not going to get into it, there's a huge plethora of law on this, both in the US as well as in India. I actually should just mention that the two laws are not identical. It's not as if you can just simply take the US law and place it on an Indian context or an Indian contract. There are distinctions and there are differences for which you need to go back essentially to your copyright law, right, in India. But the concept of work for hire, that is, I've paid you for it, therefore I own it, right? And so that issue of the creation and the assignment or the transfer of those rights, other than the moral right to assert that I am indeed the author of the book or the author of the code, but to transfer that in terms of its exploitation, because ultimately intellectual property protection is all about protecting certain knowledge so that it can be commercially exploited. I think if you keep that in mind, all of this makes sense. I mean, let's go back all the way to the 1920s, right? When the link between insulin and diabetes was discovered, the guys who did that, University of Toronto professors, chose not to patent it, right? And instead, 5 or 6 years later, we had a Danish company which still holds the patent, which came into the picture, right? And so, or you take the polio vaccine for that matter. Dr. John, what's his name? Dr. Salk refused to protect it for himself or his successors, saying that this is for the benefit of the world. But the point I'm making is that the authorship and the creation, if you look at it from a commercial exploitation point of view, all of the intellectual property regimes, it's by the way a big theoretical debate which occurs in IP law, is whether we have to follow this pure capitalist form of exploitation and therefore protection. Isn't there a better way of doing it? But I'll leave that for another session. And I think the other important point to bear in mind over here is when it comes to derivative intellectual property, right? And that is original IP versus built on a derivative IP. What about improvements, additions, enhancements, modifications, reverse engineering, decompiling, disassembling? When the English language can go on with these words, by the way, each of these words have very critical significance, especially in the technologies field. Decompiling, disassembling, these are important aspects. What happens if you engage in reverse engineering or disassembling? Let me give you an example. I did this years ago, 15 years ago. We were approached by a contractor on behalf of HAL, saying that, listen, we need to find parts for some of the older aircraft that HAL had, HAL and the Indian, it was actually HAL, right? That HAL and, the establishment had. And some of these old Soviet aircraft, some of the older MiGs, some of the older Antonovs had parts that no one knew where their IP existed. The company had gone through all kinds of restructuring as a result of the collapse of the Soviet Union. And so consequently, tracing the IP was impossible. So many of it was off patent. They'd already fallen off. They were such old, right? They were fairly obsolete, but you needed to find parts. And so we had to get into a contract where essentially this agency on behalf of HAL was going to decompile, disassemble, and reverse engineer some of those things, right? So that they could enable the building of essential spare parts to keep those aircraft running, right? Now, if you raise that question today in the context of modern technology, that's a huge issue when it comes to who owns that stuff of that disassembled, decompiled thing, because there's original IP, which you've had to reverse engineer, so to speak, right? Draw back from, so to speak. I would think, and that's the point I make over here, that as the author or the owner of the original property, you should retain your rights even to what may come as a result thereof. All right. So again, in the interest of time, we're already at 5:08. I will move quickly through. I think I've already addressed many. I've already addressed many of these points. Yeah. So define the scope of the IP, work made for hire, the ownership of the employer. In other words, it vests in the employer. The presumption of vesting in favor of the employer. Obligations of disclosures by employees to employer and non-disclosure to third parties. Then execute specific assignment documents, which is the ideal. However, what happens if you're a consultant, right? Then the work for hire concept starts to break down. It's therefore important to have specific assignment clauses to transfer the the ownership of the IP from the author or the creator to the principal, right? Or the company, yeah, the employer, right? Another very important aspect to be borne in mind over here in terms of protections is what happens when you're dealing, especially with employees who come from other organizations and competing organizations in particular. Are they carrying along with them intellectual property of their prior employer, right? And so it is important to distinguish work they've done for you as opposed to work they've done for someone else, right? And of course, again, the question of the post-termination scope as well. And here again is the only thing that I talk about over here is third-party IP, right? That is used in the ordinary course, because a lot of these things are a bundle of intellectual property, right? Mine, yours, some third party, an independent contractor, an employee. Now, if you do use proprietary third-party intellectual property, not the ones that you find in the common domain, right? The common, what they call them, the ones that are on open source, right? So if you're dealing with third-party intellectual property, you need to ensure that you've got licenses in place. So I think, again, IP protection through contractual arrangements, these are all important aspects to be borne in mind. I mean, these are just really markers, if I can call it that. I use these two slides in particular just to highlight literally a set of touch points that you should tick to see whether you've dealt with it properly in your contractual provisions or not. I now come to the last section. So, but maybe just before that, if I can have Satish come in. We have a new startup and we said we need to restructure. All right, what is the best way? And so since it's a specific question, let me answer. And this is not the place to talk about specific legal, provisions or advice. Let me just say, you asked the best way and or time to do so. I have two preliminary points to do that. When is the time to do this restructuring is entirely a commercial decision. You shouldn't be doing it for a legal reason. If you're doing it for a commercial reason because you need to be closer to your customer, then you need to find a proper legal way to do it, right? And the best proper legal way to do it is to ensure you don't fall foul of India's foreign exchange regulations in terms of round tripping, nor do you get caught up in the place of effective management from a point of view of taxation incidents. Those are the two criteria, right?
Sure.
Cost is always something to be looked at because there's a cost of doing this properly. Don't be penny wise and pound foolish, because if you do and you don't get certain arrangements and structures in place, then sadly, if you're a later stage company, you will continuously have to face the problem for it. I mean, there are several Indian companies that have gone external after many years of being in the market, so to speak. They were on the radar. And I can tell you most entrepreneurs tell me that it's easier for me to do this externalization when I'm small because I'm off the radar of many people. I'll get it done. No one will really bother about it. And it's too small at this stage, right? But in order to do that, you must get it right. Right? And getting it right means if it means spending some money, it obviates the future cost, right? I don't think many people see it because they haven't really realized the possibility that there may be future costs involved, right? And I think you say we need this in place to serve US customers and also consolidate value capture at holding level to bring investors. You've hit the nail on the head. Those are the two key points that will transition an Indian enterprise to a US enterprise. I've just had a client do that. He came out of an existing company which he sold. He's in the AI space, the analytics space, AI in analytics. Decided to set up his own enterprise, realized immediately that he had his primary partners and customers were in the US. and that he was getting serious interest from the Silicon Valley enterprises, funders. Therefore, he created a Delaware holdco immediately. It was a no-brainer for him. And yes, there were legal costs to be incurred, fairly substantial, but he defrayed that out of the investment that was coming in, and that was a clear understanding he had in place, right? So the best way or time to do this is these two aspects, right? And then to consider pros and cons. Do you incorporate in Holland? Do you incorporate in the US? Do you do it in Singapore? Now that's largely a taxation issue, right? And you should do it properly, right? You might as well, in some cases, bite the bullet by going into a proper jurisdiction. And I'm sorry, I'm using the word proper flippantly. If we had a Dutch or a Mauritius lawyer on this call, he'd take offense, because they are also, proper jurisdictions, right? But unfortunately, there are some shadows that are still lurking over there, especially in the case of Mauritius. So incorporate it in a jurisdiction way, which actually affords you a commercial connection. When people say, I'm going to incorporate in Singapore, there's a cost of doing that in Singapore. There's a cost of maintaining a company in Singapore. But there's a basis to do it, because you may actually find Singapore as an easy gateway to get work from other parts of Asia, whether it be the Far East or China. And I think that's really the place to do it. In the interest of time, I'm going to move on. Yeah.
Thank you, Siddharth. I appreciate it.
Thanks. When this is from Sachin Kulkarni. When one founder comes with an IP, can he protect his IP even after exit? Good question. I think there are two ways to do that, right? It's a very good question, because you have to basically do two things. You need to identify the relationship or the ownership, or should I say creation, authorship of that IP with that founder. Now, if it is something substantial, then you must protect it in the context of the exit provisions that may happen. Now, especially in tech-heavy companies, and I've seen this, this is one of those touch points where a founder's agreement is a good thing to have, right? Investors will obviously also want to have it in place, but then they look at it purely from the company's point of view, right? In the sense of protecting the company. Because the other founder over here is an equally interested party. And if you set the terms, or you define the boundaries now, then you will actually protect your IP at the time of exit. You should actually provide for it. Yeah. And I think similarly with Deepak's next question, will the terms and clauses of co-founder agreement be different based on country of registration from an enforceability point of view? I think the short answer to that question again is yes. But it raises an interesting question, because if you've externalized your company structure to say a US holdco, but both promoters are in India, yeah, then you are dealing with ownership interests in an overseas corporation, right? And therefore you're dealing with it between two Indian founders. In that case, it would perhaps be better to govern that contract by the overseas law, because then it's like in reverse. I know it doesn't exist, but if you had an overseas founder who had incorporated in India, right, and you're dealing with the treatment of the shares of those two founders in the Indian entity, it'll have to be governed ultimately by Indian law, because it has to meet the Indian law requirements. So I think, yes, it is based on the country of registration. But I think an important one is another situation where you have one co-founder, and I've seen this also happen, by the way. You have one co-founder sitting in India and the other co-founder in the US, right? Because that's how they deal with it, right? Because they want, the business is such that these two co-founders need to be in different places. You could have the tech guy in India and the sales guy in the US, for instance. And then what happens, right? And especially if their statuses change, I think my answer to that would be really, it's a question of where his or her assets are. And therefore, you should govern it by the law that will give the best result in terms of resolution, and then carry it into the country of his origin, India in this case, and is enforceable, right? So the US, for example, is a reciprocating territory, so that can happen. So I'm not sure if I've answered those two questions, but just some thoughts over there. I'm mindful of the fact that I need to quickly get to the last section, and I'll do that now and then hand over in the next 2 minutes to to Tara to talk about this issue, mediation for resolving contractual disputes. Sorry, again, I think it's important to understand these 6 or 7 points, actually 5 key points, if you ask me. Mediation ultimately is entirely voluntary and mutual. It recognizes the primacy of the parties and the autonomy of the parties. What do I mean by that? So you have the ability to withdraw entirely from the process or to resile from your positions, right? In other words, you get the greatest benefit of saying, I'm doing this without prejudice to my legal rights in a court of law. You're willing to go to that extent, stretch the envelope, push the envelope, and see how best you can reach an entirely voluntary agreement with your disputing party, right? So the process is contractual, consensual, and as Tara rightly pointed out to me, I'm sorry, I should have added that, it's also confidential. I think you should write the 3 C's over there: contractual, consensual, and confidential, right? And the greatest advantage of a mediated or a negotiated settlement is that you need to enforce things. I mean, look at Deepak's last question. You have to enforce it, right? Someone has to bind you to it. But here, it's entirely voluntary. Even the submission to mediation and its conclusion and adherence to that conclusion is entirely voluntary. And if you've done it voluntarily, right, unless there is a change in circumstances or a change in heart, and I don't entirely rule that out because we're dealing with human ego and human nature, right? The logic is that if you've gone through the whole process to the very end of the negotiated settlement and you've agreed to it voluntarily, you will adhere to it, right? And so therefore, it is the most important objective of this is that it's an alternative even to other alternative dispute resolution, such as arbitration, because it doesn't have the stick. If I can put it that way, mediation is entirely carrot-based, right? Let me put it like that. And then, of course, we have the state of play. I'm going to hand over at this stage for Tara to give us a couple of points on this, especially on some experiences. Tara?
Yeah, thank you, Siddharth. Thank you for that presentation. Very, very informative. And I think just to touch on the points that you raised of founders' agreement, 2 aspects of thinking about dispute resolution and, of course, unforeseen circumstances. The pitch that we're trying to, or the awareness that we're trying to bring through the mediation desk at TiE is to be able for businesses to be able to think about the dispute stage at the early part of your business. So to set systems in place wherein you are still in control of that outcome of that dispute, where you're able to access quick and efficient resolution, which is what mediation is. And to put it simply, dispute occurs or disagreement occurs. Let's not even talk about dispute stage. Disagreement occurs. Parties will sit across the table and try and negotiate. If that negotiation fails, what are your options? And through a process like mediation, which is a voluntary process, but if you have paperwork in place that takes you to mediation, what happens is you bring in a neutral, professional third person into that negotiation who's able to bring you back into a constructive negotiation phase and get you into settlement. 85% of these negotiations or facilitated negotiations end up in a resolution. And let me tell you how an IP dispute that we recently did. It was basically a founder scientist that had a team of senior scientists, part of his R&D team. 5 years into the business, the R&D scientists or the junior scientists leave and they start their own business. The founder scientist obviously feels that there's been usage of his design and technology and files a suit against these junior scientists. Years in court, because these are criminal cases, these are civil cases. Is there infringement or not is the question. When you come into mediation, again, the way we're thinking about this is not necessarily about is there infringement or not. It is what is it that the parties really want over here, and to get them back into a space of negotiating. This process goes into understanding, yes, the law is important, and all those documents that have been worked on at the stage of conceptualizing this project is extremely relevant in the negotiation. But there's also the aspect of trying to understand what is it that the parties really want. And through this process of discovery, basically we're able to understand that the founder scientist wants to be able to identify and protect his IP. And there's a lot of confusion about what is his IP, what is the junior scientist IP, and what is their IP, right? And of course, for the junior scientists, it's about being able to move on with their lives. These are, extremely highly qualified professionals with much ahead of them, but they're mired in litigation. They want to move on with their lives. So we bring in experts. We're able to use the experts to be able to identify IP. What is the IP that they agree to being the founder scientist? What is the IP that they agree to as joint IP? How do for the use of the IP that was identified as the founder scientist, there were payouts that were made. So the whole aspect of resolution moved from, is there infringement or not? What is right and what is wrong? Where is the legal violation taking place and where it has not? To how do we resolve and move on? And to that extent, the ability for businesses to structure these processes in as part of their dispute resolution strategy is a critical way for you to be able to maintain relationships, to maintain business prospects, and to be able to move forward with the core aspect of why you came together. So again, that the TiE mediation desk has been set up by CAMP and TiE in order to provide that opportunity for businesses to access these kinds of processes before you move into stages of, the more difficult options of arbitration or litigation, and to use them essentially when these processes don't work. Now, of course, when it's a question of law that needs to be determined, of course, you move directly into arbitration or litigation kind of forums. But these are important steps to be set in place as you think about documents, legal frameworks to protect your business. But we're the end of time. I don't know if we have any questions over here to give our audience a chance to ask your final questions before we close with this.
There was one question, Dara, from, I'm not sure from whom, about talking about a non-resident co-founder, an NRI co-founder, right? And whether it's a foreigner, I don't. My answer to that is yes and no, right? It depends on the specific facts. The baseline is that a non-resident is a foreigner, Indian or otherwise, right? However, the application of India's foreign exchange rules depends in part upon the types of accounts he has in India and where the money is that he's using for his shareholding. So Mr. Yadu Rag, I think, has raised that question. Yes, there are different versions. The touch point is to ask the two questions. At what point in time did he become a non-resident? And how does that impact shareholding? Those are the two related questions. And the other question is the account through which, the bank account through which he's going to be using for either purchase or sale of the shares. It's a little more complicated than that. Well, I mean, not complicated is the wrong word. It's a little more involved than that. But it's important to understand these two aspects. Who, when, and which account. Not sure if there are any other questions. Sorry.
I don't see any more questions. I think with that, we'll hand over to Shreya to close up.
Is there time for one question?
Please, is that Samir, is it?
Sandeep.
Yes, Sandeep, please go ahead.
Yeah, so you mentioned something about fines and imprisonment of the persons running the company. And I was just wondering, if it's a limited company, then there's liability protection, isn't there? And like what exactly, I mean, why would someone be fined personally for something that the company does?
Okay, let me put it like this. The liability of the company is limited, right? Sorry, let me take a step back. Sorry, I'm wrong. Scratch that. Let me address it like this. The liability of a shareholder in a limited liability corporation is limited, right? So that's the benefit of the separation of the ownership and the management, the classic company. Now, the liability of the company is never limited. If you've borrowed $1 million, you're liable $1 million. If you've borrowed $100 million, you're liable $100 million. That's the company. Now, the separation which exists between managers and the company's liability can sometimes go away depending on the circumstances of the claim. So to give you just one example, if there is a breach of duty, directors are personally responsible for the debts of the company. That is there's a section of the Companies Act specifically for that, right? Now, the only other place that is important, and what I was alluding to, was what's the concept of an officer in default. If you are the managing director of a company, you are responsible for the operations of the day-to-day aspects of the company. And if the company does not do something in accordance with law, the law says that the company and every officer in default is liable to fine or imprisonment. That is the tag of being an executive director or an executive person, key managerial personnel, right? So there are three aspects to this. Company's liability is never limited. Shareholder liability is limited as an owner, but manager liability is either because you've done something wrong and therefore you're responsible, or the law fixes a liability on you because you are deemed to be in control of the company, broadly.
Okay. Thanks.
So that's why the Companies Act says, if you've not, for every violation, the company and every officer in default is liable for a fine, which may extend to rupees 10 lakhs, or to imprisonment to extend to 1 year or 2 years, or both. Of course, over the last 2 years, this current government has reduced a lot of this criminal aspects in the company law in the last 2 years. Right? But that's the one. That's the one thing.
Thank you.
I think someone else had one last point. So there was. Please display the summary slide again, Samir. Which summary slide, Samir? The original one. This. Well, I think that was it. Any more questions? I don't think so, Tara. So I'm hand back to you.
Thank you, Siddharth. I'm going to invite Shreya in from TiE to close this for us.
Thank you, Tara. Thank you so much for your time, your contribution. I'm sure our audience are going to have a lot of takeaways from this session, or rather they have had a lot of takeaways from the session, and they're going to go back with a lot of awareness about all the things that Mr. Siddharth has mentioned. Mr. Siddharth, we really appreciate your time and your knowledge. We look forward to having more sessions with you. And to the audience, thank you so much for being here in this session. Tara, would you want to announce the next activity we are going to have, the pledge activity?
Yeah, so this is something that we're working with TiE on, where we're working with individual companies to understand more about mediation, to take on a pledge which along lines of when in a dispute situation, every attempt will be made to try and resolve through alternate processes like mediation, to negotiate, bring in a facilitated neutral into the negotiation, so that there is the highest possibility for resolution before decisions are made to take it to more adversarial processes or to just let the dispute go. So this is part of corporate governance. It's part of helping companies become dispute wise, These are processes that are being used around the world to protect and promote businesses. And we are working with TiE actively to get this understanding enhanced and actually pledged upon so that businesses start equipping themselves to prevent disputes and manage it in a much better way as well. But yeah, as Shreya pointed out, we will be having a series of discussions now on the mediation pledge to get more and more businesses speaking the same language when it comes to resolution. But thank you, Siddharth.
Thank you. Thanks, Tara. Thanks,
thank you for
thanks,
your
Shreya.
always support.
And appreciate
and we look
everyone.
forward
Thank
to
you.
continuing work together.
Absolutely.
Thank you all. We'll be in touch.